So that's what Harry Waite's intention was to
I totally believe it. I don't think it's so unusual.
Tyranny.
Yeah.
Well, and also the Milwaukee Journal Sentinel was there.
Broadcasters Association, yep, and they stepped it up. And there's the Wisconsin Open Records Council. They're on board. They're coming in from all over now. I mean, this Racine case has exploded. The Open Records case in Racine has exploded.
Well, good morning. Welcome back to Talkin' Racine. I tell you, it's good to be back, guys. You know, I spent a weekend up in Rothschild, Wisconsin, which is about 250 miles from here.
Whoa. Rarefied air up there.
Yeah. So here I am with Mr. George Myers once again, and Mr.
Welcome.
Jim Spodek.
All right.
And I remain Dr. Ken Jorgen, in spite of what I went through this weekend. Yeah, it was 24 hours of classroom time I spent.
Ooh.
The good news is the Packers and the Brewers both won.
Yeah.
Now, we gave you a little teaser last week about the embroilment between Sandy Widener and the city attorney. And there, in fact, was on, when was it, Tuesday or Monday?
It was Tuesday, wasn't it? The 5th? Or,
No, there was a hearing.
27th.
It was a contempt of court hearing.
Right.
Where she was being charged with contempt of court, allegedly for releasing information from a case that the judge had declared sealed.
Right.
And of course, in the newspaper, he claimed, and in fact in court, he claimed that the only reason that he had sealed it or closed it is because both attorneys had agreed to that. Both parties had. We know that's not true. Sandy did not agree to that. She did not ask for that, and neither did her attorney. So
the judge is kind of snaggled by
starting out
the
right
city
there.
attorney.
Yeah. I think the city attorney has got him a little bit bamboozled. Yeah.
Because judges don't do anything like that on their own.
Right.
No.
Judges hardly do anything on their own, except maybe give the jurors a break or something like that. But it's generally done upon motion of the attorney. So he listens to what the attorney argues, because the attorney wants something done in the trial or the court or whatever it is. And so it's up to the judge to have plenty of legal background and a fair understanding, so it makes a ruling on whether to do that or not.
Right.
But it always starts with the attorney, almost always.
He's the impartial arbiter.
And certainly is something as big as sealing the records is not going to be done on his own. That would have to come.
And you know,
from
one of the points I want to make is that when it went into that courtroom, it was that she had asked, the reason she filed for an open records was she was asking for the PowerPoint that they used to send her to the ethics.
This whole thing is just a discovery motion. It's not a lawsuit.
Yeah. How did it get to sealing documents?
Yeah.
That's the interesting point.
Something that had already been put up on display for the entire council. It was a PowerPoint presentation. Right. Alderman Widener just didn't take notes at the time. She recognized a lot of it, but she wanted each and every one of them because that was what was going to be used against her at the ethics hearing, and it had been shown to the entire Common Council. You know, so
well, why would she take notes? I mean, she showed up. She had no idea that she was going to be the object.
No, that's right.
It would be like if Jim and I talked before you got here, and we decided that we were going to rake you over the coals.
Yeah, you're going to.
You know, and you came in completely unexpected of it.
Every week anyway. I'm used to it.
All right, why don't we go through this recap here, and we'll just take them one turn at a time, and we'll each take turns reading them. You can go number one. You can go number two. I'll go number three.
The first one is that in July 2017, Sandy Widener announces a run for mayor. Now, the reason that's on the list is because we think the impetus for this whole thing, the ethics thing, and resulting in now in the discovery action and then a sealing of the court, all started with her candidacy for mayor.
I agree.
Right?
I agree too.
All right.
Yeah.
So that's kind of what it looks like, because right after that, on August 22nd, that's when the city attorney calls for this
special executive committee. He calls for an executive committee to put together. Now that he calls all 15 aldermen into that was on August 22nd. Now we're only talking 3 weeks after she announces for mayor. All the aldermen are assembled in apparently the mayor's chambers. They go through a PowerPoint, and it was on Sandy Widener.
Actually, I think it was done. Wasn't it done at the council house?
Well, maybe, I don't know. But the fact is, it was closed session. Closed to the public. They were given all this information that Sandy had given emails out to the public, and they then apparently in the executive committee, which again it was assembled by all the alderpersons, which is usually not the
assembled by the city attorney.
By the city
of
attorney.
All the alderpersons.
And
yeah.
I mean, I guess just laid Sandy out on this, and how terrible this kind of information cannot be given to the community. It's attorney-client privilege. She, I think she was taken back by it.
It was kind of like in the old-time movies where there's one person sitting in a chair and everybody's like, the lights are on them and everybody's
What gets me is, how can 14 or 15 other aldermen stand there and watch what happened there when they know dang well that information that she was putting out there could be put out.
It's pertinent information for the community to know is the thing.
Yeah,
exactly. That's the idea. And some of it was a little bit touchy. The thing about do we even know was the drug the employee that had failed the drug test and given employment anyway? Was that
I don't even know.
Okay.
I don't know. But the fact is, there's probably got to be some great emails in there because they sure are working to keep this closed.
Yeah. And then on September 17th, which is just a few weeks after the August 22nd meeting, the Common Council agrees. Now they agree. This was recommended by the city attorney, to send this question to the ethics board. And of course there was like an announcement in the paper, and even though they didn't splash it out there, Widener accused of ethics violation, it was presented in such a way that everybody knew.
Right.
Anybody who had any sense at all and had watched this at all knew that Sandy Widener, during the height of a campaign for mayor, was being sent to the ethics board.
Right.
I mean, how damaging is that to your credibility?
It sounds like one of those leaks. Yeah. In other words, because it came up in the campaign, and I think some of the campaign workers had countered that at the doors. Where somebody said, "Well, isn't she going before the ethics board?" So apparently it looks like it was politically motivated.
There was no doubt it was politically motivated. All of this is. Because she loses the race for
well, you're getting ahead of yourself here. Now, George has got number 4.
Weiner asked for emailed PowerPoint that were used in the executive committee. Told by Letney attorney it was a closed committee, so they were unavailable. So in other words, what Letney was claiming was that was given to the aldermen strictly as confidential material, and they couldn't see it again.
Yeah.
Unless he said so.
Yeah. Well, it was a PowerPoint that he brought in on that meeting and said, "See, these emails that she sent this out."
It's the evidence. And here's where it gets really critical, folks, is that he's withholding evidence, and he's using these on the PowerPoint presentation against her to pursue his ethics charges against her. So,
but not allowing her access to it.
Right. Yeah, as anybody knows anything about defenses, even TV gets this right, is that you have the right to see the evidence being used against you.
Right. Yeah, I'm going to court, but I can't have any information.
You can't find out what we said, even though we showed all. And that's where it gets really. City Attorney Letney, it was a closed committee, so they were unavailable.
You're guilty. Of what? Yeah, it's a secret. It's privilege. I can't tell you what you're guilty of, but it was bad.
We don't want you building up any defense.
Well, here's the other thing. Aldermen are sitting there, and I've said that in the paper, naive and just, what are you doing? I mean, this is happening. If it happens to Sandy Widener, it's going to happen to you.
Another thing.
It's a way to control.
Another thing that I learned long ago, because I would, I'm a landlord, so every once in a while somebody's got to, sue the landlord. But when you go to any kind of a trial, civil or criminal, it's not supposed to be a gotcha type of thing. Mm-hmm. You're supposed to you're trying to achieve justice, and the only way you do that is everybody gets all the information beforehand, so that they can, both the plaintiff, a complaining person, and the defendant, as well as the courts. Everybody has to know what's going on, and all we're trying to do is sort through it and then find out what's credible and what's not credible, that type of thing. But you get to know all the information, all of it.
You discuss and you argue and you compromise or whatever, and an impartial body, which is either the judge or a jury or an arbitrator,
will decide
makes the final decision.
And that getting that information is called discovery. You get to discover. Right. So when we talk about discovery, that's what we're talking about. So Sandy, that having been evidence, it was shown to the rest of the council, was going to be used against her. she has a right to that. That's part of the American way. None of this secret stuff. We go in a closed thing and we're going to prosecute you and all this type of stuff under wraps.
Okay, now I'm going to say it. Sandy lost as being mayor. So in October.
She did?
Yeah, she did. Yeah.
No wonder the city's so screwed up.
But she did. She lost the race.
Now that's October
that was
2017, right?
Yeah.
So now, September was where she was going to be sent to the ethics board, and then she started her suit for discovery.
Never went.
Well, after that, it's like, well, after she lost the race for being mayor, there's no more talk about ethics. It's all kind of just disappeared. All this information that was...
Well, that's my point here, Jim. Number 6. Yeah, you're stepping all over my lines. December 2017, with no ethics board meeting and none planned, Widener again asks for the PowerPoint emails. And again, none are provided. So she's thinking to herself, well, what is going on with this ethics complaint? What is going on? What's the status? I'd like to get this cleared up. Anytime you have something like this hanging over your head, it causes some discomfort and some anxiety. She wanted to be done with it. So once again, she says, show me the PowerPoints. I want to resolve this. They won't give them to her.
Now, no ethics board meeting just simply means the ethics board didn't happen to meet that month.
Didn't meet. But, I mean, it just...
it was still pending.
Well, if it was that important, they could have scheduled one,
We're talking August, the executive committee. In September, they approved the Common Council to go to the ethics.
Right.
So you had October, November. Now you're in December, still nothing.
Yeah.
How long does it... if it's so critical, and they had brought in 15 aldermen, all of a sudden now it's like, well, it's not as important because she lost the race.
Yeah, because she was out of the race, and then we're going to be worried. But the charge was still pending against her.
Absolutely, it was pending.
And if anything, it could have been used maybe as a tool. Against her, saying, "All right, now
she was never really charged with
Sandy."
Right. She was never really charged with anything. It was just a heavy public
it's
inference.
a club over your head.
Well,
exactly.
but she was being brought to the ethics board. She'd been recommended for an ethics board, and the evidence had already been shown.
Right.
Why they were doing it. Now, none of that got thrown out. Nobody said, "Okay, we're dropping it."
Right.
They just didn't hold a meeting.
Correct.
But she continued to want to get the information so that she could defend herself when it comes up again. And it's a good thing to get it cleared up. Because otherwise, it's always held against you. You sit there, well, let's see, I got to make sure that I don't do anything to tick anybody off because they'll
Think about
start
it,
this up
George.
again.
I've got this club hanging over that one alderman
That's exactly
who
right.
supposedly has asked too many questions, given information to her constituents. Actually ran for mayor. There's a lot of things. We can keep that club over her head.
And she wants to get rid of the club.
Absolutely. She wants
which makes sense to me.
Absolutely.
I would want to do that. All right, so
in December she obtains an attorney and sues. I guess you wouldn't call it sue, but requests the open records in the court system. Wants that PowerPoint in the court system.
Right. Well, she started a lawsuit to get it, which makes sense.
Right.
And essentially, she's having to do a lawsuit to get discovery.
Right. And how many times do newspapers request open records? They don't get it. They have to go to court to request the judge, can you hand over this stuff that I am entitled to and my citizens, because the government is the people's business.
Make them give it to me, Judge.
Right, exactly.
I need it. I deserve it. I legally have a right to it.
And number 8.
That's right. Then, 3 days later, email packet is given to all aldermen. Now, what the heck is that, Jim?
That's the one where a packet is given to all the aldermen. Now, apparently it had the emails in it. I'm not sure what it was. But apparently the word was that they didn't obtain or contain all the emails that were on the PowerPoint. Mm-hmm. So apparently... So now we're going to we're going to hand them over. So they asked for it has to be dismissed, Judge, because I gave them the information. I didn't not only give it to Alderman Widener, I gave it to all the aldermen. Well, apparently it didn't contain all the emails that were in the PowerPoint. I still want the PowerPoint, was Widener's contention.
Well, then how else are you going to confirm that they're all there?
Right.
And you could very well, when you saw those PowerPoint, one of them might have happened to strike you.
I think that's probably
what was that?
Yeah.
And didn't remember them all, but you remembered one in particular, and it just happened to be one that wasn't in that packet.
Right.
Then you know something's being withheld. I could see where that could happen too. Is all I'm saying. I don't know.
Right.
I think one of these days it's going to be the dog ate my PowerPoint.
Yeah.
Right. It's coming.
Okay. Then Letney hires an outside attorney to represent himself and the city, and he asked for a dismissal of Sandy Widener's suit. Now, this hiring of outside attorneys, reminds me of something, and I know it reminds you guys of something too. And it goes back to 2012. Mayor's slander lawsuit, that's Mayor Dickert, cost cities, taxpayers $100,000. That's the case where the mayor had slandered, allegedly, a former employee of the city while he was on WRJN, and there was a big back and forth about the whole thing. And it was finally decided that the city should pick up the tab, the legal expenses for this case. Now, this wasn't a big case. This was a guy suing, and you know, I mean, it's like basically like a small claim suit, except it was more than small change. And so they hired Attorney Cohen for this.
The same attorney that's on this case.
Same attorney, yeah. And when it came back, he submitted a bill for $107,000 in total. That's what the total expenses were to the city. $107,000. Now, I did some calculations. He was getting paid $265 an hour. Another attorney by the name of Elaine Eakes was getting paid $150 an hour. If we round it down to $100,000, let's just say there was $7,000 in legal costs, you know, for filing fees and stuff, which is an extraordinary amount for a case like this. I mean, but I just wanted to get it down to $100,000 so we can have a workable figure.
Round number. All right.
Yeah. So what I'm giving you here is an extremely conservative estimate. Now, if Attorney Elaine Eakes worked one day exclusively on that case, 1 8-hour day, that would mean that Attorney Cohen worked a total of 9 weeks and 2 days, 372.8 hours, exclusively on that case. 9 weeks and 2 days. Nothing else, 40-hour weeks. If he worked one day, 12 hours, that's $2,040. And if Miss Eakes worked the remainder of the time, and that's her charges represented the balance of that $100,000, that would represent an 8-hour day on his part, 16 weeks and 2 days on her part, exclusively to this case. 40-hour weeks.
4 months just working on this little case.
Okay, if they worked together,
pretty outrageous.
The same amount of time, if they both worked the same amount of time, it comes to 229.8 combined hours, where the two of them worked on nothing else but this case. That's 5.7 weeks of combined efforts. 5.7 weeks. Two people completely devoted to this case. Either that or there's something fishy about the billing.
It's almost 6 weeks, yeah. Just working on this little case about did he or did he not say what he said on the radio.
My question is there any wonder why some people are calling for a forensic audit of the city? With these kind of charges being approved and us paying for it out of our tax dollars?
Did Attorney Letney ask the Common Council for the right to hire outside counsel to fight one of the aldermen or to represent the city in this case of open records? I mean, this is almost
whenever I've seen a lot of meetings where something will come out of one of the committee meetings where the city attorney has requested outside, be able to hire outside. He's even done it where he wants to do it himself and not hire an outside attorney. I've seen that. I don't remember specifically which cases were, but it's not that uncommon.
Well, the fact is, how much is this costing?
How
much is this costing the city of Racine? I think there should be open records if you get it on how much money has been spent.
You're calling the Sandy Widener case.
Yeah, the Sandy Widener case, and this is all done in secrecy because Sandy can't talk about it. She's all of the case that's been completely going onward in the secret. So now it's starting to come ahead because of the Milwaukee Journal article that came out. But now,
I don't understand how he could hire, just on his own, hire an outside attorney to help him on this case.
Right.
I don't know how that works. Anything I've seen of the council in this particular part of the council activities, that's not the way it's done. You get the permission first. And there's often, and I don't know if there's an estimate of expenses or not. I haven't paid that much attention.
Well, I think
to it.
they have a contingency fund, basically, was what you would call it, for outside
outside.
attorney help, and
Yeah,
it's been,
that's right.
it's been about $200,000 a year that they estimate it's going to cost.
All right. And it'll probably say in the request that there's so much in the contingency fund, that's enough to cover this case. It'll be something like
Well,
that.
I mean,
Yeah.
but you have no aldermen asking questions. I mean, that's one of my beefs is where are there's 14 other aldermen. Where are you? You know, that's
Yeah, I
mean,
mean, and what's with Letney? This whole thing of him suppressing the alderman's right to get information.
George, you know those
And-
babies are juicy as hell. Those emails, you know that.
Yeah.
Well, they might reveal something, but they're not going to reveal anything that is that endangers the city. That's really should be considered confidential. And
Oh, I agree, but I mean, you know, the fact is they
You mean
just
the emails that were in the PowerPoint presentation?
Yeah, I think-
Well, yeah, no, there's not going to be anything there today. No, yeah, you know, typically
I know some of them were
folks-
sent to you guys, and that's
Yeah,
probably
yeah.
the biggest objection.
Typically, this type of stuff that goes in a closed session is when it's personal information. You have to discuss. the
Right, no, I'm
person.
not talking about that,
Yeah.
George. I'm talking about the fact that what this email leads to what?
Yeah.
What does this email
Oh,
lead
you mean,
to?
yeah,
Oh, I mean, I
stuff,
think
yeah.
there's definitely some areas there that, you know, you follow the trail a little bit, you're going to find, you know, what's really at the end of the line.
Trail closed.
Yeah.
Trail closed for repairs.
Right. So now let's just go to February the 5th. That's the court date now. Now the court hearing is coming up.
Mm-hmm.
And that's the one we brought up last week, where I brought a camera to that hearing, and it was I was asked to leave because they had sealed the case.
So what was you know, how did it get sealed? What was
That's the trick, George. How did we seal the case?
Yeah.
She had asked on open records, I'd like the PowerPoint. How did it end up getting sealed? How did these PowerPoint that apparently was given to all the aldermen, they all had it, so what are we sealing?
Well, it had to have been by request of Letney to the judge.
I think we've gotten it down to
There's
that,
no
yeah.
other way that it could have been done.
Sandy wouldn't have wanted it.
No, I mean, she
think
was
said it
asking
sealed,
for it.
right?
And I'm
Yeah.
not sure the judge just came up and said, "Oh, we should seal this case." No, I think there was some discussion
I think
prior to it.
yeah.
I don't care what anybody says. I think there's some discussion, and I think the judge had some discussion with the defense.
And I think that's actually prohibited, isn't it?
It absolutely is prohibited,
Yeah.
but I think that's what happened.
Yeah.
What's prohibited now?
How else would this take place?
The dis-
It's what is it called? Extrajudicial conversation or
Yeah.
something? I don't know. There's a term for it. I'm
Yeah.
probably wrong, but basically, the judge is not supposed to discuss the case with either the plaintiff or the defendant.
In the absence of someone. Oh,
In
yeah,
the
yeah,
absence of the
that's
other
right.
party.
Yeah, that's only extremely emergencies. I mean, anything I know about
well,
it.
Yeah.
I'm not sure. How does this all kind of melt together when actually the plaintiff, the judge almost sides with the defendants who want this information to be sealed up and kept quiet? Something not right. I mean, and then he
Yeah,
seals the case. Well, of course,
Yeah,
after the Milwaukee Journal.
you know that this hit the news works.
Oh yeah, it's all over the country.
Yeah, in fact, I looked up a
Oh, you got a list of
places,
where it's
yeah,
appeared?
where when I didn't print up each one, but it just skipping through my list, it hit Milwaukee, the Wisconsin State Journal, Reason Magazine, which is D.C., the Washington Times, that's the East Coast, the New York Times Union, the San Antonio News, that's heading back out west, the Torrington, Connecticut, the Chicago Tribune covered it. I mean,
The L.A. Times covered it.
Wasn't it in somewhere in Florida too?
Yep.
these are just the ones that, just the ones
No,
that
it
I
got
got.
picked up by
Oh,
the
okay.
AP. It went across the country because open records is a big deal to
Yeah,
a lot of people.
To a lot of newspapers in
Yes.
particular. So this has hit national news. I mean, it's people are concerned about this. That here we are, you know, not only sealing a court, but what's most interesting, we're sealing a court, sealing a court case that involves open records, which
Yeah.
is just. Wait a second, that's taking it a step beyond.
That's
It's one
pretty
thing
bizarre,
to
yeah.
seal a court record about a child or a criminal case or something like that, but this is an open records request, and we're sealing the proceedings of an open records request. So Letney's really taken it a step beyond.
I think they're in
pushing
some
that.
tall grass now, and I think there's a long ways to get out of there.
And Judge Gashikevitz has openly acknowledged and stated that this is the first case in his 9 years on the bench that he has closed or sealed.
Right.
All I
First
can
one.
say is that was a great convincing job by Letney.
I got to tell you, I mean, I give that.
First, you managed to do it, Scott.
I wouldn't buy a used microwave from the guy.
Well, I mean, it took some convincing, to do
Right.
it, because the judge has never done it before.
No.
And
I'll tell you what I think,
didn't he
George.
undo it now as a result of the
Well, he's
outcry from
now,
the country?
I don't know what happened, why the case is open now. I mean, we're not going to seal it now. I mean, I never said we were going to seal it. Oh, it was all over the documents. Everything's sealed. Everybody talks sealed.
Well, let's talk about what the hearing was this past week. It was about contempt of court.
Right.
Letney wanted to file contempt of court charges against Alderman Widener.
No, wait,
That's
before
what
we
that
do
hearing
that,
was about. It
after
was a
that case
contempt hearing.
was sealed, Alderman Widener asked that it go to the appeals court, the Wisconsin Appeals Court, which is now apparently, in the Milwaukee article, it states it's not on the roster. And apparently it hasn't been, it's been done.
You're talking about calendared?
Yeah,
By the
appeals
court? Okay.
So it's been stalled here in Racine somehow to get to appeals court, because I know that usually they're like, bam, they get up there right away. And this is from March or April, when they sealed it. It hasn't got to the appeals court yet, or at least on the calendar. Something's fishy with that alone, but we can move on from there.
Well, interestingly enough, there were some people that showed up for that hearing. One of them was a fellow here from a local guy, a private citizen by the name of Harry Waite, who's a open records advocate, among other things, and he's a staunch defender of citizen rights. And he filed a motion to intervene and open the open records and hearings to the public. Why would he do that? Why would some guy just randomly out in the community say that I want this open?
No, wait a minute. Randomly out, is he from Racine?
Yeah.
Racine County.
Okay. Okay. Well,
Why would he do that? Because he's protecting the rights of all citizens.
Yeah.
I
guess the obvious answer to me to that.
Yeah.
I mean, there's a lot of people. I mean, you got 3 people right in this room here.
Yeah.
100% of the people here
right.
are
But this was a sealed case.
concerned about that.
Yeah.
This is what freedom is all about. You have an open and honest government. As soon as you start secretizing parts of the government,
right.
that part is where you're losing your freedoms. I mean,
what do they call it? You came up with a famous saying about that. But it's about fascism. How did you word that again?
Tyranny?
Secrecy is the foundation for fascism, or something.
What I said is that any tyranny I was talking about, the foundation to keep that tyranny alive and well is secrecy.
Yeah.
They cannot when people find out, people are basically good. When you get it out into the community where everybody knows it, you're not going to come up. You don't come up with tyranny. You don't come up with loss of rights. You come up with freedom.
Yep.
And so any tyranny relies on secrecy for its existence.
So that's what Harry Waite's intention was to.
I totally believe it. I don't think it's so unusual.
Tyranny.
Yeah.
And also the Milwaukee Journal Sentinel was there.
Broadcasters Association, yep, and they stepped it up. And there's the Wisconsin Open Records Council. They're on board. They're coming in from all over now. I mean, this Racine case has exploded. The Open Records case in Racine has exploded.
Yeah. Alderman's job is to have good communication with his constituents, so that he or she can relay information to the constituency, and also good communication with the staff. So it gets information from the staff and they can pass it on to the constituents, so everybody knows what's going on. See, but when an attorney comes in, a member of the staff, this is Letney, comes in and gives information to the alderman and then says, you can't tell anybody about it, and he pulls this attorney-client privilege reasoning, that is utterly, that's an abortion of the attorney-client privilege concept. Attorney-client privilege by law can only be claimed by the client. It says right in the statutes it can only be done that. And the only time an attorney can do it if he's doing it for the client. So the point is that's a good law, because we need openness in government, and that's what we're running head up against this. And there's a lot of people interested in this across the country. This is just Racine, Wisconsin, and for one alderman to stand up and make this stand, and all of a sudden it explodes across the country.
Yeah.
That's a good sign as far as I'm concerned.
Yeah.
That
No, I
indicates
agree
that
with you.
there's still a concern about closed governments and freedom in this country.
I would argue one thing with you. It's not an abortion, it's a perversion.
Perversion.
But yeah, you're absolutely right. This is a huge issue.
We'll compromise and call it a miscarriage.
Yeah, okay. All right. Yeah, exactly. But the miscarriage was only necessitated by perverse activity.
Yeah.
Anyway, we're glad that the rest of the country is paying attention to this.
I am too. It's very enheartening, and it just is a little case, a little discovery case. Boom.
But we all need to pay attention to what's going on in everybody else's communities, because we're all
tied together.
Well, that's right. That's right.
I want to just say that, for her to stand up like that takes a lot of guts.
Absolutely,
she's
it does.
tough. She's tough as nails.
And you see it. The other aldermen are being very quiet about this.
Yeah.
I mean, there's been no objection to anybody else about the sealing of records. I haven't heard anything from anybody else. And
I mean, if this was your representation on the council, where you drag one alderman in and put an ethics violation on her for doing her job. I mean, what does that say about the rest of that common council? Just
well,
shocking.
and if your theory is right, that the reason this was all started was because she ran for mayor, you can see what the administration thinks about the aldermen and how they want to keep the aldermen under their control.
Yep.
It's done largely through, well, one is more knowledge. In other words, the staff has a pretty good idea of exactly what's going on, from every dollar being spent, every road being fixed, every park, whatever's going on. Somebody knows about it. But there's also this other side of it where they don't want anybody to know about it. And, don't want other people viewing it because, and I've seen some things in the budget done by some people that I think highly of in staff that I just consider virtual. Well, it's not really criminality, but it's abusive.
Well, we brought some things up.
Abusive about the way money is spent, particularly in that capital improvements program. But as long as it's kept quiet and under wraps, and
well, what do you think is the outcome of this? I mean, these open records, obviously, no one's fighting this hard to keep information from the public.
I would. Considering the support, I think Sandy's going to prevail. I think she'll not only get those records, but it's going to be also almost an embarrassment to whoever participated in it when you find out what's in those records.
Yeah. Why do you want to keep her quiet? I mean, there's something. I mean, obviously, she was calling for a forensic audit.
Well, she's been the alderman that has always called out questionable activities on the part of the administration.
She's always done it. She's getting stronger, and as she goes further into it, I didn't want to say her later years, but as she's getting more experience in it, she's getting stronger at pursuing it.
And Sandy's somebody who raises a stink about
money
being wasted or misspent, and there's millions of dollars that happened down at Machinery Row. And
I think there's a lot there. And I personally, I think Machinery Row is the.
Oh, and you brought up Milwaukee. It harkens back to the pension scandal at the Milwaukee County.
I think this is big, and I think it's
that spearheaded Scott
bigger.
Walker's career.
Yep.
No, the thing is that this goes on. This goes on in government ad nauseum. It does, and the thing is, it needs to be brought out, and the only way to bring it out is to open government up, because once you open it up, and anybody can go in there and see it, which they should have a right to. If it's a free country, and the government is supposedly our government under our control, we should be able to go in there and see it at any time. Anything that goes on in there, barring some very personal stuff, that applies to individuals and their medical records or something like that. But other than that, no, it should all be open, every bit of it, as far as I'm concerned. I don't.
Well, they've gotten it to the point where they just operate impunity, with impunity, wide out in the open. Well, look at the $4.5 million that they brought in for raises theoretically for engineers and nurses, and the bulk of it went to who? The director of finance.
And who looked at that? Who? I mean, I didn't hear any reports other than on this program that the nurses and the mechanics that we were concerned about got the 50-cent an hour raise, and the guy that was proposing it got the $20,000 a year a bonus. And it goes on, and now we're going to run out of that money, and then what are we going to do?
Well, Racine is in this condition because of situations like this, and hopefully maybe this will break the barn door open. I hope.
If we could make, but I tell you what, I don't think this is going to do it on its own.
No,
I think it's going to take some pushing on that door.
Yep, I agree.
It's not going to, it's open a crack now and it'll open automatically now.
Yeah.
Well, this is festering. This is not over. This is developing. I believe that this is in the early stages, and there's going to be hell to pay for a lot of things that happened and a lot of things that are being
You're going to see
shielded here.
Yep.
That's the real reason that this is sealed, because certain activities don't want to be brought out into the open. That's what I believe.
Well, and is Letney operating totally on his own over there at
Right.
City Hall?
There's another good question.
I mean, he does have a boss. I think it's the mayor. I don't know. Maybe the city administrator too. I mean, we haven't even talked about their involvement with this type of thing. What's
going
their
on behind the
involvement
scenes?
in secrecy and that type of stuff? You know.
Well, there's going to be another hearing on Wednesday.
Right, Wednesday.
Because last week's hearing was actually postponed.
The 3rd, October 3rd.
Yeah.
1:30 at the 7th floor of the courthouse.
Yeah, if you want to go down there and see
1:30,
democracy in
right,
action or take part in it.
1:30, 7th floor. Put that up on the
The
screen,
judge
please.
has now ruled that that's not a closed
Right, not
session,
closed.
so it's
Thank
open
you, Harry
to
Wade.
Yep, and the Milwaukee Journal Sentinel as well.
Yeah,
Absolutely.
yeah.
So,
big guns coming in there saying, "Open it up."
yeah, if you want to see democracy in action, come on down to the courthouse on Wednesday. At what time?
1:30.
1:30. What floor?
7th.
7th floor, 1:30.
What time was that?
You're killing me now.
Okay, well, that's it for today. Thank you for being here. We hope you have a pleasant remainder of your day, and we will see you next week, and I'm sure it's going to be interesting.